Evening, everybody. Welcome to the three-member administrative panel hearing of the Anchorage Board of Building Regulation Examiners and Appeals. Date is December 12th, 2016. We're gathered together to hear an appeal today. I'm going to ask for your patience. This is my first attempt at chairing one of these, so I may get lost once or twice, but we'll make it through. Start off with Tana, if you please call the roll.
Okay. Preston McKee.
Here.
Ray Hickle.
Here.
And Sterling Strait.
Present.
For staff, Kent Colhase.
Here.
And Sam Severin for legal.
Here.
And from planning,
Al Hart.
Christine Bedell, Long Range.
and we have a quorum and we are ready to go.
All right, let's do that. First item on the agenda is approval of the agenda. Do I hear a motion to approve the agenda? Move to approve. Second. All in favor? Aye. Aye. All right, we have an approved agenda. First item of business is the hearing that we're here for today. Before we dive into it, I want to go over what order of business of what we're going to be doing today. This is out of the Anchorage Code of Ordinances, Section 23.10.016, Order of Business for Appeals from Action of the Administrative Official. And this gives a very clear order of how we're going to go through this presentation today. Right up front, I want to make sure everyone is aware of where we're going, the appropriate time for questions and answers. And so nobody's surprised as far as where we end up. First thing we'll do is we'll have the chairman will introduce the case. I'll get to that in just a second. The appeal number will be read into the record. Of note, all testimony is given under oath, so there will be an oath for anyone who is giving a testimony today. First up, the staff does a very brief outline of the case. That's followed by the appellant giving their presentation. After the appellant gives their presentation, the staff and any witnesses make their presentation. Both the appellant and the administrative staff, in addition to the board, may ask questions to the presiding officer of the opposite party after each presentation has been completed. So after both the appellant and the staff gives their presentation, any questions can be solicited at that time. After the staff has given their presentation, the appellant has the right of a rebuttal. Any party may be represented by legal counsel. Formal rules of evidence applicable to action at law does not apply to hearings before the board. Only requirement is the evidence be relevant to the matter before the board. Burden of proof rests with the appellant, who must convince the board by preponderance of evidence that the appeal should be granted. The findings of the board shall be specific findings of fact and conclusions of law. The affirmative vote of a majority of the fully constituted board is necessary to grant an appeal in whole or in part. And at the end, the chairman shall advise the appellant of the board's decision and advise them of appeal provisions. Any questions to start off of our procedure here? All right. And to start out with, we're here today to listen to appeal BCA-05-2016, appeal of demolition permit denial. The name of the party appealing per our appeals form is Peach Investment Corporation. So with that, I'll ask the staff to give a brief overview. Please keep it to 3 minutes or less. This is not your full presentation. This is just a summary of what we're here today to discuss.
Thank you. Kent Colhase, building official for the city.
Kent, I do apologize to make sure I'm doing this right. Since you are giving testimony, can I ask you to affirm the following? Do you affirm under penalty of perjury that the testimony you're about to give in this matter before us is the truth?
I do.
Thank you. All right, carry on.
Okay, so our case is essentially presented in the memo, the staff packet that was distributed. I believe went to the board, hopefully went to the appellants as well. And that really lays out kind of what we're going to talk about tonight. So I don't know that I need to go through it right now in detail. A couple things I would say. I know that there were some discussions or email traffic today between the appellant's attorney mention is that I believe everybody's aware there is an emergency ordinance in place that was enacted on October 18th that prohibits the issuance of building permits or any demolition permits rather for this property. That expires on December 18th or 19th. I don't recall exactly which date. Upon expiration, absent any other action by the assembly, the appellants would be eligible for a permit to be issued at that time. If needed, we have Hal Hart, the Director of Planning. Christine Bunnell works in long-range planning as the Historic Preservation Officer for the municipality. They're available to answer any questions that may come up. They have both been involved with the research on the historic easements and discussions about the Fourth Avenue Theater in general for the past couple of months. So I just wanted to make folks aware that they're here and available to answer questions. Anything else I should touch on, Sam?
Nope, I don't think so.
That's all I have.
Okay. Thank you very much. At this point, I will turn it over to the appellant for presentation. Who will be presenting on your behalf?
Thank you. My name is Joseph Reese. I'm a lawyer with Davis Wright Terrain, and I'm here on behalf of Peach Investment Corporation. With me here today, Joe and Maria Fang, right next to me. Next to them is their son, Derek Chang, and Terrence Chang is over here. What we're talking about here is
Mr. Reese, if I could interrupt you real quick.
certainly,
As you're giving the presentation, can I get you to affirm the following: do you affirm under penalty of perjury that the testimony you are about to give in this matter is the truth?
certainly I do.
Thank you very much. Carol.
Well, what we're talking about here is a demolition permit application that was submitted on October 17th of this year. The demolition was for the property that includes the Fourth Avenue Theater, which, as everyone knows, is fairly controversial. The representative of Peach Investment Corporation was Terry McGovern. And Mr. McGovern, I had hoped would be here, but he had a conflict. He was actually departed on his vacation to Hawaii, his first vacation in 8 years, and with his family of 8 kids. So it wasn't possible for him to be here. And I do have an affidavit from him that I submitted earlier, and you may have already seen, just outlining what happened on that date. So it's an affidavit under oath that I'd like to ask that you consider as evidence in making your deliberations. The second person that I had hoped would be here was Howard Hancock, the Chief Title Officer of Fidelity Title. That probably is not going to be as important because the municipality has conceded that there is no issue as far as whether or not there is a historic easement, conservation easement on the property. Mr. Hancock's affidavit, though, I would ask that you accept it as evidence because it has dates in there of the original conservation easement, the agreement between the bank and the municipality, and the trustee's deed for the foreclosure. And those dates, I think, are important to what we are going to present to you today. Because what we're going to ask you to accept, and we feel very strongly that the application that was made should have been granted on the spot. And applications, as Mr. McGovern says in his affidavit, he's been doing this for years and years. He presents lots of applications for demolition permit, and the normal process is you present the application and you present your fee, and the application and the permit is written right there on the spot and given. And that happened with the application he presented the very same day for the Northern Lights Inn. He presented the application, presented the fee, and he got the permit. And that's typical, that's what always happens. When it came to the second permit, which was for the Fourth Avenue Theater, there was a flag in the file. And the flag said, seen as Bunnell. And the issue was whether there was a historic easement. And the dates are important in the affidavit of Mr. Hancock, because the original conservation easement and the agreement with the municipality was 1985. The trustees' deed that foreclosed that out and that wiped out that historic easement was 1990. So 26 years ago, that historic easement was gone. During those 26 years, was a lot of history having to do with the Fourth Avenue Theater. And those of us who've been around for a few years, I've been practicing law here for 35 years and lived in Fairbanks before that in the 70s. Those of us who've been around a while know that, have a memory of the Fourth Avenue Theater, the acquisition of the Fourth Avenue Theater out of foreclosure by Robert Gottstein and Iditarod Properties. Robert Gottstein gutting the inside, taking out all the seats, making it a venue for events. Robert Gottstein getting into trouble financially, being about to lose the theater. The offer by the Rasmussen Foundation to loan a low-interest loan to the municipality to buy the theater if they wanted to. Then that the assembly didn't take them up on that offer. The opportunity that was given to the voters to vote for a bond that would have given money to acquire the theater, and the municipality would have owned it. That failed. There's a lot of history involved. All through that time, it was obvious that the conservation easement was gone to anybody who looked at the public records. For the municipality, for planning and zoning to tell you that, well, they didn't know whether there was a historic easement or not on the property. It just boggles the mind, to tell you the truth. All it would have taken is a look at the public records to figure that out. All it would have taken was a call to the municipal attorney's office, which has some attorneys who are very well versed in real estate, could have looked at those records and said, it's not there. Look at these documents that Mr. Hancock in his presentation or in his affidavit said. It's not there. There's no historic easement. All it would have taken would be a few minutes of time to verify that. Instead, there was a flag on that property record that said, if anybody applies for a demolition permit, see Christine Bunnell. Well, as a result of that, when Mr. McGovern applied, Ms. Bunnell came out, and as Mr. McGovern says in his affidavit, she came out and said, there is a historic easement on the property. We don't have the documents for it, we can't find them right now, but we need to research it. That flag was put on, according to the memo that presented to you by the municipality, that flag was put on in August of this year. It wasn't some old historical record that had just never been erased. It was put on in August of this year. So what we argue that the evidence shows pretty clearly is that there was either a mistake that was indefensible for refusing to issue that permit, or there was a plan that was put in place to put obstacles in the way of the property owner getting the demolition permit that they should have been entitled to in order to stall. And the next day, there was the emergency ordinance was passed. So either it was a plan to put those roadblocks in the way, or it was just a mistake that was inexcusable because it was so obvious to anybody who had looked at it that there was no historic easement there. So what the evidence shows is that the permit should have been granted right there on the spot. It wasn't granted on the spot because of a statement that there is a historic easement, we have to research it. That there's no excuse for that. And so what we're asking you to do is to put that right by having the department issue the permit as of the date that it was applied for, before the emergency ordinance went into effect. It will still be subject to the emergency ordinance until that expires, but you can have it issued as of October 27th, and the time told during this time of this appeal and the historic easement, so that the time that the property owners have to enact it doesn't start to run on October 27th, but starts to run as of the date the emergency ordinance expires. And that's the remedy that we're asking for, just to make something right. The idea of tolling the time and making the time start running as of the end of the emergency ordinance is a means to give them additional time, give the property owners additional time to talk to the municipality, which they've been trying to do. And I'd like to have Mr. Fang give you a little bit of background of what they have in mind for the development of that property, and what the demolition permit was all about, and what efforts they've made with the municipality to try to work out, because they recognize the historic significance of the building and what it means to the community, and they want to work with the municipality. So I'd like to ask now that you go ahead and swear in Mr. Fang so that I can ask him some questions.
All right. Good evening, Mr. Fang. Do you affirm under penalty of perjury that the testimony you are about to give in the matter before us is the truth?
I do.
Thank you. Proceed.
Thank you, gentlemen. My name is Joe Fang. Maria and I have been in Alaska for nearly 30 years now, investing in the local real estate market. You may or may not be familiar with some of the projects that we do. The first building we built was the 3000 C Street at C Street and Benson. That was during the absolute, I think the last part of the market, late 80s. The second building we built was the 188 Northern Lights building. Probably familiar with that, the tall building standing on the edge of we were always a little bit reluctant to build that building because the footprint was a little bit small. The parking would have been very, very efficient, turning around. And when the Fourth Avenue Theater and also later the Wheat Building became available, it was our intention to build something adjoining those two buildings. And we have always been fully conscious of the historical value and the sentimental value of people attached to Fourth Avenue Theater. And we have always told the local population that we would do whatever we can to preserve the historical significance of this building. So we went to the city, as you may or may not know. It took us 5 years to plan this and many, many hundreds of thousands of dollars of investigation and preparing reports, and we asked the city if they would contribute to this, help out in this endeavor, because we were planning to build a multi-use hotel, residential, and office and retail building in this fairly big piece of footprint now, which included the KeyBank Plaza, the lot next to it, the Wheat Building, and something on top of the theater. It would have been, I think, I would say about 500,000 square foot complex, and it was in line with everything that the city wanted. It's mixed use to building, it encouraged development. We were going to hire about 100 people or so, and it was going to revitalize the downtown. We thought we can't lose. All we are asking for is tax abatement for a few years in line with, we're not asking for anything special. I mean, it's written into the law that this is a curated property which is simply approved. We're entitled to request for tax abatement. And we prepared a 250-page proposal to the community, and thought it was, the assembly approved it enthusiastically, and we thought it was kind of a slam dunk, and lo and behold, we got turned down for what we thought was no reason at all, because they said we didn't provide enough details. So anybody who's developed this kind of project will know you can't provide very much detail until you know exactly what you're going to be building there. And if you want to detailed drawings, it's going to cost you $2-3 million. We provided all we could at that point. But anyway, be that as it may, we kind of took it, and decided, okay, well, if the city doesn't want us here, we'll do something else. Next thing we knew, we got, the best way to describe it is a dawn raid by the city. They sent down a whole team of people to Northern Lights and presented us with, what do you call it, court order to search the building, and they found evidence of people living there, and that it wasn't up to code, and that they wanted us to bring everything up to code and secure the building. And we told them that we were going to demolish the building all along. Okay, and the mayor told us in that many words that he wanted the building torn down, and we made a commitment to have it torn down by the end of 2017. But with this new order, which they said if we don't comply, they were going to fine us so many dollars every single day, we had to scramble to get the building torn down. That is the background of why we decided to go and apply for a demo permit for the theater, because we don't want to be exactly the same thing to happen to Fourth Avenue Theater, that they would come down and say, do something with the Fourth Avenue Theater because it's not code compliant, and we know it's not code compliant. So it's a protection mechanism more than anything else. At this point, we have no plans to demolish the Fourth Avenue Theater. Okay, at the same time, we are faced with a lot of very difficult issues with the Fourth Avenue Theater, because, well, with the Fourth Avenue, the Northern Lights Inn, we can demolish it, very easily at a considerable cost. It's not so easy with 4,000 feet because of all the public opposition. At the same time, it costs a lot of money to maintain that building, as you all know. You have to heat it up in the summer and in the winter. The boilers are failing now. All the floors, the biggest problem is that all the floors are dry rotted out, and it's a fire hazard waiting to happen. So do you go in and keep putting money in? We put in over $1 million in the time that we have owned it, paying the taxes, putting on a new roof, trying to put Band-Aids to everything in there. But at some point in time, we have to say enough is enough, because everything you put in there is a total, it's just dumping money down the drain. Okay, those are the issues that we are faced with. But right now, we are faced with the issue of having to do something inside, okay, and we need a demo permit for the Fourth Theater. I'd like to say that we are citizens, we have our rights, we are applying for something within the law, and we hope you will uphold the law and grant us this demo permit. I'd be happy to answer any questions you have.
Questions from the board? I have a question. When the demolition permit was requested, there's a discrepancy between the municipality's statement on this and the statement both in your appeal permit and in the affidavit from Mr. McGovern. And that's that in your guys', in the appellate's discussion, it states the demolition permit was denied, whereas in the municipality's statement, it's phrased that there was a mutual agreement to do research and reconvene for the Senate. Can you confirm that your guys', the appellate's position on this, that when the demolition permit was requested, it was denied, and that there was no discussion of mutual approval or mutual agreement of further research?
Yes, Mr. McGovern's affidavit explains what happened, and what happened was that he was told, we can't issue the permit. We need to do research because there is a historic easement, we've got to find the documentation, so we can't issue the permit. It's not, this permit is not the kind of thing where you have a stamp that says denied or approved. I mean, it's, the typical thing is you go in, you put in your application, you pay your fee, and it's written up. When it's not written up and not given to you, when it's refused, and there's an absolute refusal to give it to you, then that to us is refusal is a denial. Then you don't have to have a stamp that says denied. You know, it's they did not issue the permit based on a completely erroneous and fictional historic easement.
Would you say you disagree with the statement then in the municipality's packet that says it was mutually agreed that both parties would research the easement and then the parties would get back together to discuss the findings? Was there mutual agreement there?
No. What Mr. McGovern describes in his affidavit is just what happened. He was told, we can't issue you the permit, and we have to research it. And so he said, something like, I'll go back and tell my client. What else can you do? You can't appeal it on the spot. You can't. It wasn't given to him, and so he left. There was no agreement for mutual research.
Then after the permit, as you say, was denied, did you or did you not go about doing research as stated in both parties? What research did you do after that point?
Well, after that point, we certainly went back to just to verify that there was no historic easement. And that's when, we found those documents, recorded documents that are of record, that show it was gone 26 years ago.
So there wasn't an effort to recommunicate back to the municipality at that point to show that that had happened and to try to get your permit at that point?
Well, the next day, the assembly passed the emergency ordinance that said there would be no permits issued. And so there was no ability to say, well, now we've done the research, we can show you this, issue the permit. No new permits could be issued. So the only avenue was to appeal.
To echo Mr. McKee's question, did you have any discussions with the municipality as to your findings in the interim before you filed the appeal?
No, I don't think so. There have been discussions with the municipality that on the building itself. Mr. Terrence Chang has had a number of discussions with them, but as far as the demolition permit, the only legal option we have was to appeal. I do have, if I could, I have some questions for Ms. Nelson. She is here, and Mr. Potter is here, and I'd like to ask him if he has something to add to this. Okay.
What I ask that we do for that is we include them in part of the staff presentation, and we can ask questions to them as part of the staff. They may have a presentation, may answer some of the questions. So,
Yeah, my only intent was to try and respond to Mr. McKee's question.
okay, if it's a follow-up from that question, then absolutely all that. What would you like to ask?
Ms. Bunnell and I did have a conversation over the phone before the emergency ordinance was put forward by the municipal attorney that following Tuesday. And I indicated to her that it was my recollection that, trying to give her a starting place, that when the foreclosure occurred back in 90 or 91, that in fact the bank or the city's preservation lien or easement was foreclosed out because it was in a lower position below the banks. So she was aware of that and certainly had at least a couple of days to have researched that based on that heads up. I guess the bigger question, since Mr. McKee is asking, did you make an attempt to try and get back to the city to discuss that issue? There were about 2 days, part of that over a weekend, and I guess the question that I would hope that you would be asking is that if in fact the issue would have been raised on the date, August 18th, when the initial flagging of that property was done, that would have given 2 months for the city and or the property owner to do the adequate research to show that in fact the easement was not there. That's the significant question that should be asked.
Okay, and I apologize, I'm falling behind, but catch us up. For the record, could you state your name and can you affirm that under penalty of perjury the testimony you have already and will give in the matter before us is the truth?
Yes, my name is Timothy C. Potter, P-O-T-T-E-R, and yes, I affirm that everything that I say here, to the best of my knowledge, will be the truth.
Great, thank you very much. Any questions from staff or anybody else for the appellant? All right, then the final thing I'd like to ask is just to make sure we're all on the same page, we know where we're going. Can you state again what it is that you wish would happen if the appeal is granted?
So certainly, what we're asking the board to do is to grant the appeal and order the planning department to issue a demolition permit for the Fourth Avenue Theater property dated as of October 17, October 17. I've been saying 27, and I apologize, it's 17. October 17, 2016, and a tolling period so that the time that the owner has to operate under that agreement begins to run as of the date that the emergency moratorium expires.
Okay. Thank you very much. And with that, we'll move on to the staff. Any witnesses on the staff's part to make their presentation?
Okay, thank you.
Can you start us off?
Yeah, Kent Colhays again. As I mentioned before,
And real quick, again, to interrupt you, apologize for the interruption, but do you affirm under the penalty of perjury that the testimony you are about to give in the matter before us is the truth?
I do.
Thank you.
As I mentioned in the, excuse me, in the introduction, the memo pretty much lays out the municipality's position, but I'll kind of walk through it and be glad to answer any questions that I may ask Ms. Fennell to speak briefly as well. In August, early in August, I was asked by the planning department, specifically Ms. Fennell, to put a note in Hanson requesting that she be notified if application for permit was made. I did that. As the building official, I have, I guess the permit management system is under my umbrella of authority. On October 17th, as it knows, Mr. McGovern came in. I wasn't in the building at the time. I understand that they called, the counter technician called both Ms. Fennell and Mr. Hart to the counter. And maybe at this point, Christine, if you could, is it okay if I ask her to?
Absolutely.
Okay.
She needs to be sworn in, so we file before we vote.
And can you state for the record your name, and do you affirm under the penalty of perjury that the testimony you're about to give in the matter before us is the truth?
I do. My name's Christine Bennell. Just to clarify a couple of things, we have 33 properties that are listed on the National Register of Historic Places, and each of those properties will be listed in our database in case somebody does come in and ask for a permit. So it's not just the Fourth Avenue Theater that would be affected. I wanted to say one quick thing about, for those of us that have been around and should know, which is something that was mentioned earlier, Mr. Reese mentioned that he's been here for X amount, 35 years, or I don't know, whatever it is. I've only lived in Anchorage for about 5 years. And so all the history on the Fourth Avenue Theater, and I've heard that in hearsay, but I was never a part of it. And with the conversation with Tim, we had recently received about 13 boxes of historic documents on a lot of the historic buildings that are in the Anchorage area. And there's quite a few conservation easements listed on all of those properties. So while, yes, there was some time that passed, we really haven't had a chance to do that final research, which is what Sam did for me, because we just haven't had time. Anybody knows about the land use plan project that's been going on? I've been tasked on that project too, and that's been the #1 priority for the mayor. When I was called up and Hal went up with me, I very truthfully, I said to the gentleman that came in there that we had received documentation that at some point in time there was a conservation easement on it. And even though Tim and I had talked, like I said, I still hadn't had a chance to review it or have our attorney certain things like that, we want to make sure that the attorney gives us guidance on, yeah, you know, this is gone, this is whatever. We just have to have those determinations made. And so we went back and I started diving into boxes right then and there. And I couldn't find exactly what it was that the title documents and everything until Mr. McGovern had actually left. So our attorney's office, I scanned everything, sent it over to them immediately, and they started working on it, and it took a few days for anybody to make a determination, because it's from years ago, and I don't know if they had, if I actually had a complete copy, and if they had to do other research. So basically, I put it into the hands of the attorney, called them when Mr. McGovern was in there, because I didn't want to do something, I just wanted to be upfront and let him know what was going on. We both agreed, as Kent mentioned in the letter, that we're going to work on it. I said, please tell the Fangs I apologize. Let's look at this together and make sure that we get this figured out. And he said, okay. And then I guess he continued to work to get his other permit for the Northern Lights, and then he left the building. And we left it at, once we had made a determination that we would either be in contact or they would be in contact with us.
Thank you, Christine.
Sure.
I guess the other thing I want to touch on is responding to Mr. Reese's statement that a permit should have been issued on the spot because it's a demolition permit, and that's just the way things happen. I provided some code citations in the write-up. I'm not going to read them, but clearly the code envisions that the building official has the authority and the duty to ensure that all applicable laws and regulations are complied with. That is, I guess, really the basis of the ability to deny any permit. It's described in several places in code. And I guess just to summarize, I don't see a need to keep talking. My understanding, what I was told by our staff, is that there was a mutual agreement at the counter to part ways and research the existence of the easement, to the historical easement. To my knowledge, as I said in here, I'm not aware that the owner's agent came back in the near term until we received the appeal. I just touched on the fact that the building official, I don't believe, is absolutely required to issue a permit upon application. And don't know that I have any other points, Sam.
Was the permit denied?
Well, in my opinion, no. There was an agreement to do some research and come back in, and that didn't happen. As I said, I either was not in the building or was not contacted, so I was not asked at that time whether or not to issue a permit. They acted on the notation that was in the file, in the permit file.
And if there was or was not an agreement between Mr. Bunnell and Mr. McGovern, wouldn't affect whether a permit was denied.
Correct.
Okay. Sorry, that's a complicated question, but that's all.
I don't have anything else. I'd be glad to answer questions, or if there's further questions for Ms. Bunnell or Mr. Hart or Mr. Simmons.
I've not been involved with a demolition permit, but I get electrical permits quite often. And so I guess my question to you is, what's being said as a normality of a demolition permit being issued on the spot, is that always the case? Because in other permits, we have to jump through a lot of hoops to make sure that a lot of things are in place to get an electrical permit or a fire permit or something like
couch my answer just to let folks know that I've been the building official for about 7 months, so that's my experience basis. In general, I would say that a demolition permit, a permit for demolition is generally issued on the spot if there are no known outstanding issues. It is different. They are handled administratively a bit differently than permits that require plan review or subsequent submittals.
So there's no real plan review involved, unless there's a flag.
Correct.
To follow on to Mr. McKee's question, what are the requirements for submitting the demolition permit? Just the form? Is it, what all goes into a demolition permit?
I don't have the code in front of me. I believe it's the basic requirements are a completed application, and there's a fee that goes along with it. I don't recall the fee.
Nothing like a typical building permit with plans and
Correct.
details? Okay. More questions?
The fact that they're routinely easier to have drafted though, or to get issued, do you feel like you're under a mandate through the code or otherwise to issue them promptly, immediately, without considering all the circumstances?
I do not. I think the code envisions that due diligence is taken upon issuance of a permit.
Yeah, I have some questions if I could, before we permit. Mr. Colhase, would ask you, with this particular permit, was there any issue raised as to the other requirements that you pointed out in your memo, other than the historic easement?
I'm sorry, could you?
Did the application for the demolition permit that we're talking about in this case raise any issues other than the historic easement?
It did not.
And I have some questions for Ms. Bonnell, if I could. Ms. Bonnell, you're the person who talked to Mr. McGovern when he came in and applied for the permit. is that correct?
I did, and Hal did too. And the clerk had done. I mean,
Through the chair, she's referring to the permit technician.
Okay, so there were 3 of us talking to him.
Now, let me ask you about the notation that the flag that was on the property record. Are you the person who put that flag on there?
I wasn't the person to put that on there because I don't deal with that system.
If I may, through the chair. So Ms. Bonnell asked me to place the flag in the system. I directed the permit manager to actually physically enter the flag into the Hanson permit management software program.
And Ms. Bonnell, that was in August of 2016?
I really don't remember the date, but evidently Kent does, so yeah.
Okay, all right. Why did you ask for that?
Well, like I said a few minutes ago, we've got 33 properties that are on the National Register of Historic Places. We also have around 133 properties that have been identified as eligible for listing on the National Register. And each one of those properties will be flagged, so that if someone does come in for a permit, then we can discuss what their plans are for the property.
In August 2016, how many properties were flagged?
I don't know. I have no idea.
How many did you ask?
We just talked about the Fourth Avenue Theater, that was the one that we talked about.
That's the only one that you talked about then.
That day, yeah.
And you say the others will be flagged eventually.
Yeah.
Okay. Why did you pick out the Fourth Avenue Theater?
I can't remember exactly what was happening on that day. I don't really know.
And so, at the time that you asked that flag to be put on there, did you think there was a historic easement?
Yeah, yeah.
And at that time, did you research that?
No,
Okay.
no, like I explained earlier,
Okay, you picked out that
it was
one,
pretty hectic.
you picked out that one property, asked it to be flagged, but didn't research it.
It may have been I got a phone call or something like that. I have no idea. I don't remember. That was a couple months ago.
Okay, and that was 2 months before Mr. McGovern came in and asked for the demolition permit, right?
According to the letter, right? Yeah.
And during that time, you didn't try to determine whether or not there was an historic easement actually on the property.
Like I said, I received a bunch of boxes that had documentation in them on a lot of historic properties. I was able to scan through those boxes, but not make a complete determination of anything. Evidently, years ago, the Muni purchased quite a few conservation easements. And in people giving me these boxes with all this documentation, I was told that.
When Mr. McGovern came in and asked for the permit, what exactly did you tell him?
I don't know my exact words. Basically, what's written in the letter there is what we said.
And Mr. McGovern does recall that you told him there is a historic easement on this property, we just haven't found the records yet.
Okay,
Is that accurate?
that's close, yeah.
When you told Mr. McGovern that you would have to research it, did you give him back his application?
I think I made a copy of his application and gave it back to him, yes. Because he had both buildings on there, on the same application.
And you told him that you couldn't issue the permit until you'd done the research, right?
I don't issue permits, so I wouldn't have said that to him. Yeah.
Did you have the authority to withhold the permit?
Again, I don't issue permits, so I don't have the ability to do that.
Did you tell the permit clerk anything about issuing the permit?
No. Again, that's out of my power, that's not my job. I wouldn't say that to him.
Okay. And you didn't, or the office did not issue the permit that day, right?
Through the chair, no permit was issued that day for this project.
When you first asked for the flag to be put on the property, did you inform the property owner that you were flagging?
No.
What was the next property that you asked to be flagged?
Again, there's a list of 33 properties. I can't read them off the top of my head right now, but there will be 33 properties that are in there.
And how
And
many?
just to clarify that a little bit, we already have a database that, that the public as well as employees can access to find those properties to see if there's, there might be issues with permits or something like that. Issues might not be the right word. And that database is available, like I said, to the public as well as to employees. And the Meanies had that actually for about 3 years now. And I was the one that instituted that database so that historic properties, information on historic properties would be available to the public, so that they would know whether they had a property that was listed on the National Register or eligible.
This flag on this particular property, though, said that if a demolition permit was requested, contact you. Is that right?
I don't know if it, I don't know what it says. I don't have access to that.
Through the chair. The flag in the system said, do not issue the permit pending, do not issue permit pending research outcome from building official. I apologize. Let me back up. That was posted on the 17th. On August 18th, the flag was notify Christine Bunnell if demo application is made, extension 7933, which is her phone number.
Thank you.
Now, this register you're talking about of historic properties is not the same thing, is it?
What now?
The register, what you're talking about is database of historic properties that is available to look at. It's not the same thing as the flag that you had put on the 4th Avenue Theater property, right?
I don't know if the systems talk to each other or not. I'm not sure.
Are there any other properties flagged today?
I don't know.
There will be.
Yeah. We, with the assembly taking the actions that they're taking, then they'll get the whole entire list, yeah. And actually, your attorney asked for the list a while back.
So you don't know of any other properties that are flagged today?
Not that I know of.
Any further questions, Mr. Reed?
Okay, go ahead.
I have a question. This might be better suited to the applicant. You might know the dates right off the top of your head, but we know that on August 18th, the 4th Avenue Theater was flagged for demolition, or lack of, for the demolition flag. What was the date of the surprise inspection on the Northern Lights Hotel? If whoever can answer it, that's fine.
State your name for the record.
Terrence Chang.
Do you affirm under penalty of perjury the testimony you're about to give in this matter before us?
I do.
Proceed. Thanks.
September 28th.
Thank you.
With the building official, so you stated during the opening that there's now, there's no historic lien against the property whatsoever, is that correct?
Ken Coltes, building official, that's my understanding. That's the advice we've received from the municipal attorney's office, yes.
And it's our office's understanding, in keeping with Mr. Hancock's research.
So at this point, there isn't any reason why a permit wouldn't be issued at this time?
Well, at this time, the emergency ordinance is in existence, which prohibits the building official from issuing.
Understood, as far as barring anything else?
Correct, that's correct.
Mr. Severn, I believe I missed you with my list to get everyone sworn in. So for the record, can you state your name and do affirm under penalty of perjury the testimony you are about to have given in the matter before us in the truth?
Sure, Sam Severin, and yes, I do.
Thank you. Brunel. I am not fully aware of historical easements and how they work, so could you please, at least for my sake, give a 30-second description of what a historical easement is and how it would apply in a case like this if there was one?
The easement would protect the building so that it wouldn't be torn down. The building could be reused, it could be renovated, it could be repurposed, but the easement would stay there and the building wouldn't be torn down.
Does it protect the full building or just parts of the building? You talk about being able to
Well, I
renovate.
think it depends on what is described in an easement. So for some of the National Register properties in town, they're on the National Register because of the architecture, what you see from the outside. With the Fourth Avenue Theater, I believe the easement included the inside artwork and some of the architectural features on the inside of the building as well as the outside.
Great, thank you. Yes, sir.
Sarah Chang.
Thank you, and do you affirm under penalty of perjury that the testimony you're about to give in the matter before us is the truth?
I do.
Thanks.
So under the federal guidelines, even a property is listed on the National Historic Registry does not prohibit the private owner from demolishing the building. It's even true in our case because we have never received any incentives, especially on the financial side. So we have the right to actually demolish the building even under federal guidelines.
Thank you. Ms. Brunel, another question for you. You stated that at the time the note was flagged, or the property was flagged, that the note was added. It was the only property that you were aware of that was flagged at that time. Do you have any recollection as to why this property was flagged at this particular time instead of at any other point over the last 25 years since the easement?
You know what, I apologize, I should have looked at my calendar to see what was happening on that day. Like I said, we've been quite busy with the land use plan map project, which is a big project that we've had. We at that time had been having public meetings, et cetera, When I started the conversation with Kent, probably weeks earlier before that even happened, I let him know that there was going to be a whole list, not just the Fourth Avenue Theater, and it was probably just a bad day. And I managed to get the one on there.
Okay.
Hectic day, not a bad day, hectic.
We all have those. In the note, it states specifically that if a demo application is made, so is it true that this would only apply to a demolition application? This wouldn't have triggered anything if a building permit or a renovation was applied for? This was specific to just a demolition application, is that correct?
That's what they put in there, yeah.
Okay, thank you. One more question for you. After you and Mr. McGovern discussed the permit, as stated in the Municipality of Anchorage's statement here, it was mutually agreed both parties would research and get back together. It sounded like you went forward and did the research and worked with the municipality attorney. Did you or anybody from the building department make an effort to contact, it says here, make an effort to get back together. Did you ever make an effort to contact the owner to discuss your findings?
No.
Do you know why that was not done?
Well, I thought he was gonna contact me. So I didn't contact him.
Question for Mr. Coat. Is there any record in this case of what was agreed upon between the building department and the appellant? Has it been previously stated there's a discrepancy of a difference of opinion, if you may, as far as what actually occurred and what the agreement was. Are you aware of any record of what that agreement was?
To my knowledge, there's no written record of the events of that day. No.
Is it common for demolition permits to have questions that require additional research, and how is that typically handled, if so?
Well, as I said, in 7 months of experience, this is the one instance where we needed to do additional research. I'm not aware of other examples during my tenure, nor previously, but I haven't been in this role.
Okay. Any last questions?
Could there be, to issue a permit retroactive, what, that's something they have asked for, so I'm asking what that involves on your end.
I guess it's a question for maybe both of us. I'm not sure from the building departments if there's any precedent for that, or any time you do that or don't do that. That's new to me.
I'm not aware of a precedent for that. I would have to do some research on it. I would say that my research would involve the municipal attorney's office due to the existence of the emergency order. I certainly understand the logic presented, the argument presented, but currently there's an emergency order, so that effectively, in my view, bars me from issuing a permit until December 18th or 19th, whatever the date of the expiration of that ordinance is. But beyond that, I would defer that question to the municipal attorney's office, and Sam may not be able to answer that on the spot.
I can't answer on the fly. I guess I wasn't prepared for it, but it does give me some concern. It seems kind of complicated, and I don't know about extraordinary, but I'd like to know why that needs to be done. To go back and sort of backdate something and then stay its operation for 2 months or whatever the idea there seems a lot more complicated than we know. There's no conservation easement, so if they come in a week and ask for a permit, there's no real bar to granting it, and that's not a big mystery at this point. So why we have to go back and backdate something to October 17th, it just gives me some concern. I don't know if that's a good policy to start doing. I'd like to know why that's important to do, and maybe we can work through that together. I'm not sure.
And that was going to be my next question to the appellant, was the necessity for that date.
What we'll do, if you guys are comfortable with this, you guys have a chance to have an official rebuttal here in just a second, and we'll allow you guys to answer that. I think we're just about done with the question and answer period for staff. I have one more question I'd like to ask Mr. Clough.
Yes.
If, for a standard demolition permit, what is the duration that permit lasts?
I believe, and I could research and get an answer for you for certain, but I believe a permit in general is valid for a year. Ray could probably help here, not to have you testify, but they're generally valid for a year. And if some action occurs on the permit during that year, for example, you call for an inspection or submit a submittal if a submittal is required, that action resets the 1-year calendar. But in general, it's a year, and I'm not aware of a code section that states that it's different for a demolition permit.
All right. Thanks. Further questions? All right, and with that, we'll turn it over to the appellant.
Before we do the rebuttal, Mr. Potter did have a comment to make about the process of
I wanted to comment on Mr. McKee's question to Mr. Colhase. And you know, in the 35 years that I've been in Anchorage doing this and getting permits for projects, typically if you meet the measurement of all of the application requirements and you pay your fee, the application is accepted. And this is what I don't understand in this case, is that, and the attorney asked the question, were there any other outstanding issues other than the, I guess, assumed, now we know not true, existence of the historic easement. Was there anything else that would have prevailed upon the building official to not grant the permit or accept it? I mean, just accept it, because with it, typically the permits or the building permits would go through an acceptance review at the counter to go through the checklist, see if everything was there. And then if you didn't have everything, it wouldn't be accepted. If it was that everything was there, but there was still a flag, it would be accepted because you met the requirements of getting accepted. And there is an important distinction about that. There is an awful lot of vetting that goes on with the date of acceptance or your date of application. And if that would have been accepted and only been for the issue of the historic properties easement, then it would have been vetted in the system, and even the emergency ordinance may not have applied because they would have been vetted already as having applied. And that is fairly well done throughout the building permit process, that once you're in, you're in. So the zoning codes change. If you're in the process already, you're subject to the old regulations, not the new regulations. And so as the municipal attorney indicates, you know, what's the difference? Right now, from a practical standpoint, there probably is no difference, but the reality is, I believe that that permit application should have been accepted. If the issue of the historic easement was the issue, then that would have been something that would have been reviewed and resolved as part of the application review process. And it was totally inappropriate for the city to refuse acceptance of that if there was no other legal basis to deny that application. The fee was there, the application was filled out, and the building official has already indicated that there were no other issues. And that's the key issue associated with that question of what is such a big deal now about going backwards. The reality is, if it would have been accepted, I think from a legal standpoint, not being an attorney, you are looking out for the public's interest, that we would have been vetted and the fangs would have been vetted in that application. And we would not have been subject to the emergency order. So it does appear, at least in my opinion, that there were too many conveniences of timing set up through this entire process with no practical appropriate notice going to the private property owner who could be hurt and damaged by not knowing that this property had been flagged. And I can tell you that I did go to the Building Safety Department today and asked to go through 7 different properties, all of which are commercially oriented, that are on the historic registry, and none of them are flagged. So, albeit Mr. Colhase indicated that it appears the emergency order was supposedly for the 4th Avenue Theater. In fact, Municipal Attorney Mr. Falsey made it very clear that we're not just targeting the 4th Avenue Theater here. This is for all of them on the registry. But it is very interesting that the only one that has been targeted with a flag is one specific property. And Mr. Hickel, I think your question about the timing is also very interesting. And there's probably another question that should be asked as to what the motivation of the staff was and what happened just before August 18th that would have led the staff to ask the building official to flag that property for a demo alert.
May I ask a question based on that?
Um,
Or I don't know where we are now.
I would say that counts as part of the kickoff for the rebuttal. We'll let the appellant get through the rebuttal, and then we'll have another chance for questions.
Well, I'd just like to go back to where we started. I'll go on this, an hour and a half ago or so. We have an application that was made that where the only thing that resulted in a refusal to issue the permit was a supposed historic easement that everybody acknowledges now did not exist. Everybody acknowledges it was easy to determine it did not exist. The public records in the recorder's office track it. There's no mystery about it. It could have been determined before the flag was put on. Could have been determined after the flag was put on, before, but within that 2-month period. Instead, the flag was put on, the permit was refused without any real legal basis for it. And that is whether it's deliberate or not, you don't have to find that there was any evil intent here in order for us to prevail on our appeal. Preponderance of the evidence is just to show, what we need to show is that the application was made, the only reason that it was denied was the historic easement. That was an error that could have been researched well before that. It wasn't. And so the property owner was deprived of a demolition permit that they were completely entitled to have based on either an indefensible mistake or an intentional desire to slow down the demolition of the building. Either way, that was an improper refusal to issue the permit, and it should be granted now. It should be made right now. And making it right now, if the permit is dated prior to or on the date that it was initially applied for, that's before the emergency ordinance went into effect, and that's, in legal terms, that's non pro tunc, it's called. You issue it now, but it's as if it were issued on the date that it should have been. And that the emergency ordinance that was enacted afterwards shouldn't be an impediment to doing that. I just asked also point out one more thing, and that is that there was a flag, a second flag on October 17th when it was when the permit was not granted. That flag said, "Do not issue permit pending research outcome from building official." Well, that "do not issue permit" is a denial of the permit. You can call it anything you want, but that's a refusal to issue the permit. And if there had been a valid basis, or if there had been a real reason not to issue it, then certainly that's something that, as Mr. Kohlhase pointed out, the municipality has the obligation to make sure it complies with everything that the code requires. But there wasn't anything else. It was just the historic easement. So we'd ask the board to grant or find in our favor on this appeal and order that the permit be issued as of October 17th with the hold period, the tolling period on the running of it until the emergency ordinance expires. Thank you.
Please state your name for the record.
My name is Maria Chen Fang. My maiden name is Chen.
Okay. And do you affirm under the penalty of perjury that the testimony you're about to give in the matter before us is the truth?
Yes.
Thank you. Proceed.
Yeah. I'd like to tell something about my contacts with Christine here. We met her in 2011. Okay. We have conversations several times. I have a memo here, okay, back in 2014. May I read it out?
Yes, ma'am.
Okay, because it gives you some background of what she's stating now. Okay, she said, this is to my son, Derek. Dear Derek, this was dated Monday, January 6, 2014, from Ms. Vanell Christine. Dear, copy to Carol Wong, copy to Jerry Weaver, and maybe Jerry Weaver, yeah. Happy New Year to you and your family. I hope that your mother had a nice visit to Alaska when she was here in November, prior November, which is 2013. I wanted to let you know that we have developed an informational package for our CFO and legal division to inform them of the discussion we have had with you and to assist on future discussions on the redevelopment of your properties on 4th and 5th Avenues. The package includes considerable research and documentation on the need for hotel, housing, and commercial development within the Anchorage Bowl, and the benefits of mixed-use development, and supported by the 2020 Comprehensive Plan and the Downtown Comprehensive Plan. That package went forward to our municipal manager for his review and consideration last week. I included the ideas that were mentioned in our meeting, in addition to elements of an agreement that the MOA may require. At this point, Carol and I don't know if we will be contacted directly by the CFO or the legal division to discuss any future project agreement. Long-range planning may be advised to work directly with you. Any agreement would most likely have to be approached by the Assembly, which will lengthen the time frame to a few months. We will be in contact as soon as we get direction from the manager's office. Best regards, Christine Bonnell. We waited until last year. And under your guidance, we have done our master plan. So I don't know what you are flagging for this. To our surprise, I thought we did everything this department has asked for. We have many worksheets here. So, in order to provide, relationship, okay, and get a better impression to the city and the people in Anchorage, that we're trying to work with the department. We waited for this time. We never complained how much we spent. Yet we were flat for no reason. Like Tim Potter says, why on earth we were flat when Ms. Bonnell knows the history back like her past. She tells us here, she doesn't know whether we have an easement problem. Is it a memory problem here? I'm much older than she is. This is the second generation. We can retire anytime. We are seniors. We support after 29 years. And you are telling me when I buy this property, we don't know that the easement is long gone. And she doesn't know about it. I mean, the spirit is here. We are working with the community, with Alaska. Okay, we are pumping money into it. We are trying to avoid an accident. We don't want to have something like in Oakland, the fire will be with the whole street. We need to go in. Are we going to put a new boiler? And the city doesn't allow us. Why? I have to make this point to you, the board, because I know this lady. Why would she say, I don't know anything about this? Like my attorney says, you can pick up the phone call. It's all in your system. It takes 10 minutes. Why? Maybe English is not my first language. But you take my money. Every year, I pay over $1 million in tax. Have I been late? I don't publicize what we spend here. We just try to get a good business here. We've been here for 29 years. We're still having, okay, our interest in Alaska. Not me, the second generations. What have they done? They are giving. They could have stayed in California. They have stayed in Asia. We're business in Guam. We're business in Asia. We're business in San Francisco. Why is it so difficult? Am I missing something? Because I'm a senior Chinese lady. I speak the language. I understand. I buy properties. I mean, you know, we don't advertise. We're very, you know, humble people here. We never flaunt what we have. But I want to testify today. I know this lady. And maybe she has some memory problem. She doesn't know our property anymore. So she has not responded after this. She has given to the city. She will know here. Okay? In a few months. But this thing is 2.5 years old. Nobody contacted us from the manager's office. I don't know how many times the family goes and visits the mayor's office. At least 4 mayors we have gone by. We still have faith in this. We never badmouth anybody. We have faith here. So we show you faith by pouring money, using Tim Potter's Dow, using your architects, talking to the assembly people. So we don't understand. I'm using not Hong Kong dollars. I'm using U.S. currency. So what's the problem here? You are the attorney. You work for the mayor's office. You work for the planning. You don't want to see this project? You tell me my money is not good enough. So what is the problem? We want to be friends with you. We reach out for every mayor. So I'm just stating here, the legal part I have represented. But I want to tell this lady, does she forget about me? Does she know me? This is the first time I see you. I have seen the Kopath before. I think I've seen Mr. McGee in one of the development downtown with Chris Schutte. You know, familiar faces. I mean, you know, we have traveled. My husband is 73 years old. In this climate, we have traveled 2 days because the planes have been delayed, canceled. We make a point to come here. Okay, we stayed up 24 hours in order just to visit here. I wanted to come. Okay, we almost got stranded in Seattle because they canceled the flights due to the weather. We got in last night. Okay, we wake up at 4 o'clock. You know, this is, you know, you don't care about this, but this shows you our passion. I just want to reach out. Okay, I want to give you some background. Okay, I'm not criticizing anybody. I'm just stating a fact here, a fact that Miss Christine had given you. She doesn't know the easement. Come on. For somebody who writes me this letter, doesn't know the easement, who is violating the law? So I'm just making a fact. I'm not criticizing. And I urge you to at least get out to the people here that we are not going to damage anything. You will like the project if we are, you know, granted, okay, a permit. First of all, a demo permit so we can go to work inside. Anybody is welcome to look inside. We want to know what can be done. You know, it's a structural problem. How do we preserve any murals, right? We can take it down, but once you touch it, you know, the concrete may melt. Okay, it's so dead. It's an environmental problem inside. We want to have this, you know, all up to code. We understand, we build buildings. Not that we are trying to shy away. Okay, we are not. We want to to step up and be responsible. But the city has to understand, they're keeping our hands tied without going inside and try to fix it. Okay, so I urge you, here I have this as evidence that we all know that there's no problem with the easement. The easement is gone. That's what I want to tell you. And you can make a copy of this if you want to. Okay? And I hope the board will understand our frustration. Thank you.
Thank you very much. Questions?
I don't know. At this point, well, I have one question, I guess I do have a few. So, to you, thank you for sharing your thoughts with us. I appreciate it. It sounds like a tough trip, too. Is it your position that the application was not accepted? The application for the demolition permit?
I think that Kent already answered that question.
I'm asking you.
In my opinion,
Yeah.
I was not there, but if I went with a full package that responded to every item that is required to be in an application, and I had the correct amount of money, there's no assurance I'm going to get granted the permit, but on that basis, that should have been accepted.
And in this case, was it accepted or not? That's what I'm asking.
The money was not taken, so there wasn't even a contract apparently. And yes, I would say that it was not accepted, and which I am actually very surprised because that rarely, if ever, really happens. If you've got the information, whether it's a plat or a rezone, conditional use, building permit, if you've got all the information there and they go through the checklist and you got it, it's accepted. There's never a guarantee that you're going to get it. It has to go through the process, be reviewed, and then issued. But there really is no excuse for why it wasn't accepted.
If I may, through the chair.
Yes, sir.
Mr. Potter speculating, so I'll speculate in return. We don't know, I don't know, I wasn't there, nor was anybody in this room except perhaps Christine, and I'm not sure when she was there, whether Mr. McGovern, when he was informed that this consultation had to occur, whether he decided on his own to keep the check and the permit application and leave. So that is just as plausible as Mr. Potter's assertion that the permit application was not accepted by the municipality. I can't say whether that happened, I'm just offering that as a counterpoint.
Well, possibly we should ask Ms. Bunnell what happened, if she was there, as to whether or not the permit technician said, you know, we could take your check in the application, but we'll have to resolve this other issue on the easement for historic interest before we could ever issue a permit. And, you know, fair question. But if I showed up at the counter, Kent, whether it's tomorrow with another permit, and I have everything that's needed, and I have the check, I'm fully expecting that I've met the letter of the code that says this is what you have to do to get it, to submit an application. And I'll be very, very frustrated if it's not accepted. That's the way it typically goes. You have to have a reason to not accept it.
Gentlemen, at this stage, I'd like to end the speculative part of this discussion. We'll continue with questions.
I'm reading the affidavit number 8. Ms. Brunel said there was a historical easement on the property, but they could not find the paper. She said she would have to research this and would get back to me, and refused to issue the permit. She gave me back the permit application saying it could not be issued. My question is can I assume that means that the application was not accepted?
You're asking the question to...
Let's pose it to the city attorney.
Oh, I have no idea, I wasn't there. I can't answer that.
mean, that's not speculation, we have testimony here. Number 8, it's pretty clear what he was saying, and he was there.
I guess I'm not a fact witness as to what happened there. Well, as long as we're talking about Mr. McGovern, I have a question of Mr. McGovern's not here. When did Mr. McGovern know definitively that there was no historical property easement?
Well, Mr. McGovern was simply an agent who was there on behalf of his employer who was contracted to apply for the demolition permit. So what he discovered about the existence of the easement or not really is not relevant. I don't think it really matters. But the thing is that we have testimony under oath of someone who was there that the permit application was given back saying it could not be issued, and given the speculation that we've been talking about what happened, that's a fact. And to me, the conclusion that you'd have to draw from this fact is it was not accepted.
That the application was not accepted.
Not accepted.
Therefore, it was not denied because it was not accepted. Correct?
No,
Oh, okay.
of course not.
Why not? I mean, that's,
I can answer that. We've had a case with the new Title 21 and the old Title 21. If before the deadline, you got your application accepted before the plan was reviewed, you counted as the old Title 21 and fell under those rules. If you waited a day later and turned it in, you were under the new Title 21. And that's the only explanation I could see, that if your application would be accepted and then it would gone down for review before it was issued, that's what I would understand would normally happen.
I've seen the same thing happen with the code cycle change. Well,
that's fine with me.
Mr. Reitz, do you have another question or a statement?
No, not now.
Any final questions for the appellant? All right, with that, I will bring to the close the presentation and the question and answer portion of the evening. At this point, we're down to discussion of ourselves. We can ask additional questions if we so desire. And at this point, we can also make a motion for how to proceed. I will point out that for our regulations, for a decision in a appeals board, our motion should be a finding of facts. So statement should include both what the decision is. Motion should include both what the decision is and the facts supporting that conclusion. Once the motion is made, we can discuss, have additional discussion. So start things out, Joy. Someone have a motion.
I really don't know how to phrase a motion, to tell you the truth, I apologize, so.
I think we've got a couple of questions here. We've got questions as to whether or not a permit should or should not be issued. And then the second question is when it should be issued, what date it should be issued by.
So let's go to the petition.
I think that states it pretty well.
Taking advice here. Basically, you can make the motion in the positive to hear whether or not for your deliberations on whether you want to approve the appeal on the basis of this. and that is when you can go into discussion and decide whether or not that you will be supporting it or not.
Okay, I can start with that. I move to approve the applicant's position as stated.
Stated in the appeal.
Yes.
And to be clear, the position there would be building official should be ordered to issue the permit. And as has been discussed in the presentation, the permit should be issued dated on the date of submittal of the application, which would be October 17th, 2016. And the time frame for acting on that permit should be held, I believe, a tolling period was the phrase used, until the suspension or sunset of the emergency ordinance. Do I have seconds? All right, discussion.
I don't know what there is to ask. I mean, it's pretty cut and dry to me.
Which way?
You want to know how I vote? I would vote for the applicant. No disrespect to staff. There's a lot of good people in the city. I think a mistake was made, and that's the way I view it.
Understanding agreement. We should accept it as
I'd like to ask a question to council. Do we have the ability to action on this as the motion states, to essentially post-date the approval of an application and give guidance about holding the active period for the permit?
I honestly do not know. I just really don't know. I could ask a lot of curveballs in here, and I usually try to answer them. I just don't know the answer to that. It's confusing to me. I mean, we knew you were going to grant the permit, basically. I mean, there wasn't much question. But as to the backdating, it just didn't. I'm not sure if that was asked in the original appeal. Maybe it wasn't. I just missed it. But I just don't know the answer to that. I'm concerned about it. It just, to me, doesn't seem like the best practice. It just seems strange that you're ordering him to. I don't know. I don't know the answer to that. I wish I had more time to look it up, but I just don't know.
Can I add to that? Obviously, this mistake has hurt the applicant, or the appellant, excuse me. And I would like to give them the benefit of the doubt when they have to make their arguments wherever they take them, that we should have received a permit had it been the process sped up and whatever vetting needed to be done. And they're in a much better, they're made whole as best we can by giving them that benefit of the doubt, saying that we as a board find that a mistake was made and that a permit should have been issued.
I wonder about the mechanics of it. I don't know, because you have to issue a decision that Kent, in order to Kent Coles to do something. And so, I don't know. I mean, can you, that's the question I'm just asking. I'm just kind of talking through it out loud. I don't know the answer, but you issue an order to him to make a document that's effective 2 months ago? I don't know how that would work. I'm not sure.
I think the assembly's gonna sort all that out in the public hearing as well. And I'm not a lawyer. I thank the Lord daily I'm not. But anyway, I think the applicant deserves the benefit of the doubt, and whatever gets sorted out, I think the record should show that they should have gotten a permit.
I mean, maybe the question to Mr. Reese, because I have a problem with it, but I'm not trying to advocate so much against it. I just want to make sure the mechanics of it just doesn't seem right to me. What is your explanation for how is it just that simple? Just order him to date it October 17th, and that's all there is to it, or?
Well, our position is the courts regularly issue orders that are called non pro tunc. They order them now, but they order them to be effective on a certain date. And because the application should have been granted on the 17th of October, that it should be within the power of the board and the planning department to issue a permit non pro tunc. Issue it today or tomorrow with the date of October 17th, because that's the effective date when it should have been. And then as far as the tolling goes, the tolling is something that is also very common.
I understand, no, and I don't disagree, all those concepts work well in court. Part of the problem we have is that these boards aren't courts and he's not a judge. So, within the code, I'm trying to get to the bottom of it so it gets done in a way that doesn't screw everything up. Or that's not ordering him to do something that's unlawful. I mean, within the code, is there a way to get there? Anchorage Municipal Code?
Well, there's the provision in the Anchorage Municipal Code that we cited that requires the issuance of a permit. As far as the mechanics of it go, I think that the municipality has the power, just like a judge would, to determine the dates of issuance of permits, or to determine what it has the power to do. And so I don't know that there has to be a specific code provision that says you may issue orders non pro tunc. I don't think you need that.
Let me ask you this, if you were gonna do it that way, it's different from how we usually do things in the municipality, that's my only concern. If I could have a couple days to raise some kind of objection, if you do rule that way, just in case there is some kind of issue with that, I just don't have the ability to research it right now.
I believe that option is always there with any decision the board makes. It wouldn't be the first time we've done something and then been told by legal at a later date that the phrasing or the way we've gone about it was incorrect.
Okay, that's fine.
Requires modification.
I don't want to be obstinate at 8 o'clock at night at all. It's not my intention. I just want to make sure that some of those things get really tricky if we start being lax with them, and I just want to make sure we've got the authority to do it that way.
Provided it's in context with the law upon review, upon legal review.
And if not, it would take effect as of today.
And that's gonna happen anyway. We could issue that we're gonna applicant's request as written, subject to legal ability or legal review.
We can do that, we can amend the motion.
Then can we do that?
Yes, you may.
Then I want to call for the question.
Could I make a suggestion first?
Sure.
I have the same desire as Mr. Severin, that we don't do anything that is gonna cause more problems down the road. So, I'd suggest that the motion be to approve the demolition permit and order it be issued with the date of October 17th, 2016, but that if there is a finding later that the board did not have the authority to backdate it in that way, to date it in that way, that it be issued effective the first day that the moratorium or the emergency ordinance expires.
That's a lot better than the way I put it. So that would be, I agree, or,
So I'll move to amend the motion to state that with approval of the motion, we move to order the building official to approve demolition permit with the date of October 17th, 2016. However, if additional legal issues are raised as to post-dating this permit, the permit will be issued on the first day the emergency moratorium expires.
Do we have an application and a fee to?
We do not right now.
They would have to bring it in tomorrow.
Okay. There's a step, okay, just a, right, okay.
So a second for the
Yeah.
amendment.
second.
Now, before we do vote on this, I need to speak my mind on this, and I am going to sincerely apologize, but I cannot support the motion as it is stated. And the reason for that is that us as a board, we're here to make determinations about the decisions of the building official, about what has actually happened in the case, what has been done, whether it was done correctly or not. What I feel we have to look at is truly the facts of what actually happened, how it progressed. Permit was requested, there was a question about the permit, so the approval of that permit was delayed. Whatever happened in the meantime after that delay is really outside of the purview of our authority. I think we have to limit, I feel we really have to limit our focus on what happened with this permit. If other factors had not come into play, then the issues of the historical lien or historical lien, whatever, easement, historical easement would have been worked out in the due course of the process, and the permit would have been granted as soon as that was worked out. As far as I can tell from reading municipality code, as well as specifically the section that was cited by the municipality of Anchorage, it does state that plans are reviewed by the departments of the municipality to verify compliance with applicable laws under their jurisdiction. Permits must conform with the requirements of this code, technical codes, and other pertinent laws and ordinances. As far as the municipal code is concerned, there doesn't seem to be a difference between a demolition permit and any other permit. And it's not at all uncommon for a building permit to go in and there to be questions that must be resolved before it can be granted. Happens every time you submit anything, especially to the structural department. There's always questions that come out of there. So to me, this sounds like this was the normal course of events. It was submitted. There was questions. Those questions needed to be resolved before it could be approved. And in the meantime, other forces outside of the building department's control came into play. And as I stated at the beginning, I do sincerely apologize because it sounds like there are activities here that are questionable, and it is very likely. I can't say anything beyond what our board has authority over, but I feel for you guys, I really do, and I dealt with the municipality as well and had my own issues, but the fact that I see it, and the burden of proof rests on the appellant to prove that the process was not followed. As far as I can tell, the process was followed. Facts outside of their control, and the municipalities came into control that have us in the position we are now. So because of that, I cannot support the motion as it stands. I don't believe we can grant this.
I think that, the one thing that stopped was the fact that the application itself was not accepted. It couldn't go for further review. It never made it into the sign-in. So, I will, for that reason, I will stand on the motion as it was submitted.
So with that, I'll call a vote. And if you would do a roll call.
Mr. Hinkle,
Aye.
Mr. McKee,
Aye.
Mr. Straight.
No.
Okay, it is 2-2. In favor.
And with that, findings of the board shall be specific findings of fact and conclusions of law. The affirmative vote of the majority of the fully constituted board is necessary to grant an appeal in whole or part. I believe we have a majority. Is that correct? So that the appeal is granted as stated in the motion. It is my duty to advise, in this case, staff that further appeals can be directed to the fully constituted building board through a de novo rehearing if you desire to continue to appeal this decision. Thank you. And that brings the matter to close.
Move to adjourn?
Sure. Last item of business for adjournment is board member comments. Mr. Key, have a comment?
I would like to say that, tomorrow, the appellant will need to submit their application and fee to get started again.
Can I make the comment that I really want to sincerely thank everybody who's taken the time to come here tonight, taken the time to come to Alaska on a beautiful winter day. This is a process, and it's good to see that it's being used and it's being worked. Thank you all for your time. Here, move to adjourn.
Move to adjourn.
Second.
May I ask a question? Is the application contract specific? If for some reason we can't get a hold of a contractor, can
You may, yes. You or your
Guys,
assistant.
let you
once
know,
you issue the demolition permit,
I will email
anybody,
it to you.
I can hire any
To
contractor.
review. If there's any changes, send it back. And then
Yeah,
I'll
you can
send it
hire
back
any
out.
licensed and bonded
So you
contractor
can
to do the
decide
work,
what
yeah.
you put on.
But do we have to be a licensed contractor?
Well, try that.
You know,
And nobody else could
Mr.
see.
Chang, I'm not
And
sure.
this is the last one.
I can check tomorrow.
Uh,
I don't,
Because, not trying to add more shit. Nobody else
I think it's better if
So I said,
we
Scott,
apply for
please
the
just,
demolition permit
and
ourselves, pay the fee.
that's fine. You can call me tomorrow.
I tried to talk to you that one day when I filed the application.
Okay, I don't know.
You were
if
there.
I-
Was it? You were there. Yeah, I think Tana had told you that I was here for this reason, but
Oh, I'm sorry.
yeah, you didn't want to talk with us, so, but it's okay, yeah. I'll come down tomorrow with the application, with the payment too.
If you need to talk to me tomorrow,
Why don't I do this, I'll come and see you directly tomorrow.